Now we can go. This radio program intended to be for informational purposes only. The information does not constitute legal advice. The law is constantly changing. The information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. And Marshall Chriswell certainly is that. And we visit with him this morning. Good morning.
Good morning.
I hope you're having a lovely day today. It's so nice outside, huh?
Beautiful. Absolutely beautiful.
Yeah. Hey, last time we visited with you, we were talking about trusts. And I want to continue that conversation a little bit here, but it's a complicated discussion, and probably a layman such as I should not be really delving into it too deeply. I need someone who's a pro at it, and that's you. So let's talk about trusts this morning, and why a particular area of the trust laws have made it more difficult to really trust in your trust, if you will.
Sure. So what I'd like to talk about is that there are lots of people that have trusts, and we've talked in the past about the fact that in Pennsylvania you can have as far as an estate planning vehicle, a document for estate planning, you can have a will or you can have a trust. And that there are usually, for most folks, a will is a perfectly good way to ensure that your intentions are met and that you pass your assets on to the next generation as efficiently as possible. But there are lots of folks that also have trusts. And for a period of years, from about the mid-'80s up until the early 2000s, trusts were especially popular, and there were even companies. There were financial advisors, and there were estate planning companies out there that had lawyers and things that were really marketing these trusts very, very heavily. So I see a lot of people that come in and they have these giant binders of your living trust. And it's important to know that although generally they're fine, they'll do the job. Although sometimes it won't be as efficient or cost effective as you'd like, but they'll do the job. But there are some instances where those trusts have just become obsolete because of changes in the law.
Mm-hmm. All right.
And so the biggest change that has happened to estate planning law over the past several decades has been change to the federal estate tax. So you've heard politicians on the stump talking about, over the years, talking about the death tax, right?
Yeah.
We got to get rid of the death tax. Nobody should be taxed for dying. And so what happens is when someone passes, if your estate value is over a certain threshold, the federal government will impose a tax on your assets that are passing to your beneficiaries under your estate plan. Mm-hmm. Back in the mid-'80s up through the '90s and early 2000s, that exemption amount was fairly low, ranging from, I'm just looking at the list of factors here. In 1980, that number was $161,563. If any one person dies and they're over that amount, their estate's being taxed. Mm-hmm. It has crept up through the years to $600,000, $1 million, $5 million. Now it is $12.06 million. So if you die and you have less than $12.06 million, you will not be taxed by the federal government with respect to estate tax.
Well, if that's the case, then I'm in trouble. No, I'm just kidding.
No, that's the case. Most of us, all 99.7% of us, don't have to worry about it anymore.
Yeah.
It's just something that you don't have to worry about. So estate planning attorneys don't have to worry about it anymore, which is good. And so the point that I'm making is, if you had a trust that was created 20, 30 years ago, it is very likely that there are terms in that trust that were designed to avoid or reduce estate taxes.
So you started by saying that we're thinking these funds are just languishing there. They're still doing the job that they were intended to do, but now it's just not necessary to go the trust route when you come to that or a will, correct?
Right, and it's important that you get the trust looked at, because it needs to be amended or redone if it has these provisions in it. Because the way that the trusts were set up at that time, it was something called an AB trust or a credit shelter trust. And for married couples especially, you would put these things in place, and what would happen is, whenever the trust would say, whenever the first spouse dies, half the money in the trust, or all the money up to the amount of the federal estate tax exemption, has to be placed in an irrevocable trust, and the other spouse can't touch it. The surviving spouse. So what it does is it takes at least half the marital estate and locks it up in a box whenever the first spouse dies, to try to avoid estate tax on that money. And so now when you have fast forward 30 years, you've got this trust document. The first spouse passes away. The surviving spouse comes into the lawyer and says, "Okay, here's the trust." The lawyer has to say, "Okay, we've got a lot of work to do here, because we've got to unravel this trust post-mortem after this person's passed, and because we don't want you don't need this protection anymore. We don't need to lock half your assets in a box that you can't touch for the rest of your life." So it's important to avoid that complexity and the problems, to get those trusts reviewed by an experienced estate plan attorney now, so that they can be amended and redone before they cause problems.
If you do them before that spouse passes away,